Once again, we're back with Attorney Jack Golan of Popkin, Shamir, and Golan Law Offices. The address for your inquiries is 3250. That's 3250 Wilshire Boulevard, Suite 1918, Los Angeles, California, 90010. And Attorney Golan has had over 40 years of experience. He's seen everything. He's done everything on immigration, and there's nothing that, well, I'm sure later on towards the end of the program, we'll ask him if there are other things that still surprises him. But he has seen all the different cases. Now, Attorney Golan, you mentioned about the 10-year bar and the possibility of a provisional of a waiver. Now, will that include people that are on fiancé visa who entered the country and stayed behind, did not marry the person who petitioned him or her on a fiancé visa, and it's been illegal for a long time?
Yes, it will include such people on one condition, that they are able to show that they obtained the fiancé visa genuinely, that there was no fraud, that there was actually an intention to marry the petitioner.
Mm-hmm.
Okay, or maybe they even married the petitioner and then they divorced the petitioner.
I see.
But they need to be sure that the consul will not find a reason to deny them, not because they stayed illegally in the United States, but because they obtained the K-1 visa by fraud.
Mm-hmm.
So this is something that needs to be decided before they go for the interview in Manila.
Now, Attorney Golan, I'm sure you handle many cases, and you would give the wisest advice for them either to go home to their home country and face the consul for an interview or not at all. Will this be a little bit like a difficult process for someone who goes there on his own and face the consul and be asked about all the background, the past, and has to be ready with all the documentation? Will it be something that they can face without a lawyer beside them?
I think that anybody who goes for a consular interview, or anybody who leaves the United States to go for a consular interview without the assistance of an experienced immigration lawyer may just as well jump into the sea.
No, but they don't have to be personally accompanied by the lawyer.
No, this is not necessary, not required, and in many cases, or most cases, the lawyer is not even permitted to be present at the interview. But they should really be well prepared by a lawyer. I
see. And so, if there are any,
and the lawyer should advise them whether to go or not to go.
Yes.
The risk is too much.
It's a lot of risk. Did you have any situation where, well, your clients disobeyed your advice and went ahead and now are stuck, and it's a little bit complicated for them to return?
Our policy is a little bit different. If we advise a client not to go for a consular interview and the client insists, we will simply refuse to do the case.
I see. Mm-hmm. That's right. So
officially, it would be good enough if I have the client sign a waiver saying I was warned not to go, but I decided to go anyway, against the warning of my lawyer. Mm-hmm. So this covers me, but I don't want to be in such a situation, so I simply say, okay, if you insist on going, go find yourself another lawyer.
Right. Now, Attorney Golan, when your client, for example, is on his own, now the immigration lawyers can connect or communicate with the U.S. Embassy wherever they are if you have them on the retainer basis?
Usually we communicate with the embassy normally by emails.
I see. Mm-hmm.
There is exchanges of emails, and most embassies are very responsive, response to emails.
That's really very good. Mm-hmm. So better be accompanied, or maybe not, be advised by an immigration expert. And that's Attorney Jack Golan's wisest advice. Call him at 213-383-3222. There's a question here when you mentioned about, we talked about a daughter, well, this child who was born in the United States, and then later on, after so many years, petitioned for the mom to stay legally. Now, what about those babies who are born on board a plane? What type of, which is the citizenship? If they're on their way to the United States, but not really have landed yet, which country do they get as their mother country?
Not the United States.
Uh-huh.
They are probably would be a national citizen of the country of the parents.
Oh, is that right? Uh-huh. So only when maybe you've landed, you've entered the country, and the baby's born, let's say at the airport, the whatever main airport you have here, then that's the nationality of the baby, not on the way to the country.
No.
I see. Now, here's another question from someone who had, well, I've been emailing a lot about this situation, and there are people who just, well, probably it's good that they take time on making decisions and sort of like hesitant, but it would only be wise to consult with an immigration expert. Somebody who was married in the Philippines and came to the United States, stayed illegally, but found employment, and in the end was able to apply for a green card. Now, the dilemma is that in the past record, he has always maintained that he was married to someone, and it is true. However, he wants to apply for citizenship, and that wife in the Philippines had already moved on and married somebody else. He didn't even know about it. So when he applies for citizenship, although he has a green card now, when he applies for citizenship, what does he say? Married or divorced? And he is not divorced yet.
You just answered your own question.
Yes.
He's not divorced, which means he is married. He should state on the citizenship application that he is married, absolutely married. If he wants to be unmarried or not married, he should file for a divorce in the United States.
And only when that's final can he mention that he's divorced, not while that case is pending.
He can claim that he's not married only when he gets a final divorce.
Right. Now, here's another question for so many people. They have green cards, and I don't know, I would like to ask you, Attorney Golan, are they stricter when it is a U.S. citizenship application compared to applying for a green card? Because is there more research or investigation that goes on when it's just for permanent residence? Because this individual apparently indicated that she was single when in fact she's married, and she got a green card. Now she's in a dilemma whether to write the real story in the citizenship, although there will be inconsistency. So what is your advice?
Look, I assume that she obtained her green card through a petition by a parent?
No, she came here illegally, well, overstayed. And I don't know, there are people that have employment and they have green cards. And she has a green card on the basis of an employment, as a matter of fact, by an international organization.
If she has a green card by employment,
yes,
and she claimed that she is not married while she was married,
yes.
So the fact of the marriage was not material for the decision to give her a green card.
Yes. So now that she plans to apply for citizenship,
I advise her to make a true statement that she is married, if she was married, and to explain it. And if she can show that the misrepresentation that she did on her green card was not material, because it didn't matter whether she's married or not married for getting the green card. What mattered only was a petition by the employer. Okay? Then there is a very good chance that she will have no problem, but this is her opportunity to clean the record.
Right. That's why it's always advisable to retain the services of an immigration lawyer, because you know what to do and they're better protected. So 383-3222. Now, here's a question, Attorney Golan, for people. It's a general question. What happens to those people who perhaps have been affected by the severe storms and they have been visiting, or probably they have been living in places like Louisiana, for example? If they're stuck there because of the floods and other areas that have been affected by any particular natural occurrence, is there a sort of like a waiver or relief on immigration?
No, because first of all, they should not be there.
Oh.
Let's begin with this.
Oh, there's no immigration relief, Attorney Golan?
There is no immigration relief. There could be some relief if they were supposed to make an application by a deadline and they missed the deadline, that they will get an extension. But there will be no particular relief for their illegal status.
I see. So what types of reliefs do you remember in the past that have been because of some particular natural occurrence, a typhoon or earthquake, and they were not able to return home because of that?
Not being able to return home.
Yes, let's say they have traveled to the United States and they visited a particular country, or they are in a particular state where they're unable to go home because of whatever happened to their personal circumstance. Are they given a relief of sort, like an extension, because they cannot return home on the basis of the visa that they have in the passport, stamped on their passports?
Look, again, it's all a matter of timing. Okay, if somebody comes here and has a visa that expires on let's say on August 15, and he really has a plane ticket for August 10.
Yes.
But the first week of or second week of August, he's visiting Louisiana and is stuck there and cannot leave until September 15. Okay, so he may get a retroactive extension of his visa. Possible. But if somebody visa expired a year ago and now he claims he cannot go home in August 2016, the question is, why didn't you leave a year ago? So this is not something important.
I see. Nothing to worry about. Once again, we're with Attorney Golan on Immigration Update on the air.